I'm Carlos Weffe, Managing Editor of the IBFD Observatory on the Protection of Taxpayers' Rights. I am pleased to share with you the findings of our observatory portrayed in the IBFD Yearbook on Taxpayers' Rights regarding two major areas: more intensive audits and criminal and administrative sanctions. We will focus on four major points. One, the increased judicial focus on the topic of criminal and administrative sanctions, as most 2019 decisions reported to the OPTR deal with the matter. Secondly, we will see how controls for intensive audits seems to weaken. There's a trend towards the relaxation of court authorizations in the context of more intensive audits. Thirdly, we will see how there seems to be a shift away from the minimum standards and best practices used by the observatory regarding nemo tenetur and ne bis in idem, basic guarantees of taxpayers in the context of the imposition of criminal and administrative sanctions. And finally, on a positive note, we will see how there's an upward trend towards the implementation of voluntary disclosure regimes. Indeed, there's an increased judicial focus on criminal and administrative sanctions in the context of taxation. For example, out of the decisions reported to the observatory issued by the European Court of Human Rights, 85.71% of said decisions dealt in some way with criminal and administrative sanctions. 50% of the decisions reported that were declared inadmissible before the court did so as well, and 42.86% of the cases communicated to the court also dealt in some way with criminal and administrative sanctions in the context of tax matters. As well, the European Court of Justice issued, out of the decisions issued by the European Court of Justice in tax matters, 60%, that is, 3 out of 5 reported decisions, did as well dealt with some form of legal matter or legal problem regarding the imposition of criminal and administrative sanctions. And the only opinion reported from Attorney General Cocotte dealing with tax matters also dealt with the imposition of criminal and administrative sanctions. On the other hand, the Inter-American Court of Human Rights reported no decisions whatsoever in what comes to tax matters. That might be explained because historically, traditionally, the Inter-American Court of Human Rights has dealt with very, very few cases regarding tax matters. Actually, all of them were reported in the IBFD Observatory of Protection of Taxpayers' Rights General Report of 2018 that was released last year. Regarding the protection of taxpayers' rights in the context of more intensive audits, we can see that there's the judicial constraints to the capacities, to the powers of tax authorities in the context of searches and warrants for more intensive audits seem to weaken. Compared to 2018, there's an increasing trend for not requiring authorization by a court before the tax authority may enter unsearched premises. 71% in 2019, 66 compared to 66% in 2018. In this regard, the national reports stated some facts that could well be addressed as setbacks, as shifts away from the minimum protection granted by the minimum standards and best practices identified by Philip Baker and Pasquale Pistone back in 2015. For instance, there's Belgium, where the judiciary allowed tax authorities to freely access and copy all taxpayers' data, also in professional premises, and it was stated that the right to privacy is not violated if private files are copied along with it. Likewise, in Mexico, tax authorities are reported to be allowed to enter the dwelling places of individuals without any authorization whatsoever in the case the taxpayer conducts business that. And finally, Uruguay requires no prior authorization from the judiciary for the tax authorities to conduct more intensive audits, except for the purpose of searching taxpayers' dwelling places. In this regard, on the other hand, we can see that the protection of privileged information seems to be slightly improving. Compared to 2018, in which 46% of surveyed countries stated that there was a procedure in place to ensure that legally privileged material is not taken in the course of a search, in 2019 that number rises up to 55%, which is naturally very good. However, there are some numbers that demand an increased attention. For instance, Canada, Guatemala, Italy, and Peru report to be shifting away from the minimum requirement of court authorization for intensive audits, compared to the major statistic according to which 70% of countries, compared to 76% in 2018, require judicial authorization before phone tapping or monitoring internet access. Regarding banking information, Italy and Slovenia authorize tax authorities and the police to use banking information at the center of risk assessing without any court authorization whatsoever. Something similar happens also in Peru and in Serbia, particularly in the context of exchange of information. Thirdly, nemo tenetur. There's greater protection to nemo tenetur in Denmark and Peru, but Canada, Mexico, and Peru as well report some degree of lesser protection of nemo tenetur. It gets to the point in which, for instance, in China and Mexico, principle is reported to be not respected. 26% of countries, compared to 25% in 2018, have some kind of restrictions on the use of information supplied by taxpayer in the subsequent penalty or criminal procedure, whereas 30%, and this might be read as a sign of improvement, 37% of countries, compared to 57% in 2018, do not let the taxpayer invoke nemo tenetur to refuse supplying accounting information in more intensive audits. Lastly, 40% of countries, compared to 29% in 2018, warn taxpayers that nemo tenetur rights are applicable in tax procedures. So the so-called Miranda warning. In this regard, the Parliamentary Ombudsman of Denmark clarified best practices regarding nemo tenetur in a case that involved documents from the Panama Papers and is likely to have effects for the future. Ne bis in idem. Greater protection has been reported to be granted to ne bis in idem in Belgium, Colombia, and Spain. However, Bulgaria, Brazil, Italy, Mexico, and Peru report lesser protection to ne bis in idem. 54% of countries, compared to 28% in 2018, do not apply the principle to tax audits, which is a sharp decrease on the level of protection of this basic guarantee. As well, the recognition of the principle does not prevent two parallel sets of court proceedings arising from the same factual circumstances in 58 of the surveyed countries, compared to 52% of them in 2018. As from the factual perspective, many or some developments were reported. In the case of Belgium, and as well on Italy, both legislation and rulings by the judiciary were enacted or were delivered to comply with the jurisprudence of the European Court on Human Rights in the case of A&B versus Norway, allowing double prosecution and double sanctioning of tax infractions only in case in which both procedures are deemed to be sufficiently linked in substance and time. Switzerland, the judiciary in Switzerland ruled a rather narrow interpretation of the principle. Nevis in idem has been reported as to be avoided in Slovenia, and in South Africa, multiple audits for the same period are allowed, since double jeopardy only applies to criminal charges laid due to tax offenses. Finally, on a positive note, voluntary disclosure regimes seems to be on the rise. VDRs are used to reduce penalties in Belgium, Colombia, Spain, Mauritius, and Russia. 76% of countries, compared to 79% in 2018, reduced or squashed penalties because of voluntary disclosure regimes. However, sanctions are increased to encourage voluntary disclosure in Brazil, Italy, Mexico, and Peru. And particularly in the Netherlands, it is worth noting that the voluntary disclosure regime for saving and portfolio investments held in the Netherlands and with respect to income from substantial interest was abolished, was repealed as of the 1st of January of 2020. All of this information in detail, along with other many developments produced in 2019 on the practical protection of taxpayers' rights, can be found at our website, IBFD.org, on open access, absolutely free of charge. There, on our website, you are able to download both the IBFD Yearbook on taxpayers' rights corresponding to 2019, as well as all of the national reports, the information based on which the OPTR team prepared and delivered to you and compiled to you all of this useful and practical information on the status, on the real status, on the practical protection of taxpayers' rights. If you want to further communicate with us, if you want to share your impressions, if you want to participate somehow in the work of the observatory, please drop us a line through optr@ibfd.org. Thank you very much for your attention, and please stay safe.